Previously we talked about immigrating a parent, but what if the parent overstayed and they're here illegal? Can you still help them? Watch this video and I'll tell you more. So in this video we'll talk about options for parents that overstayed their visas and now they're being petitioned by their US citizen children. We did a previous video that we talked about the process of immigrating a parent. But this video we're recording is based on a question that we got from one of our viewers, and I wanted to create a video specifically for that, to answer the question of what happens when a parent overstayed and has a criminal violation. Can you still adjust their status? But before that, I wanted to ask you to subscribe to our channel. If this is the first time you're watching this video, subscribe to our channel and click that bell to be notified of any new videos that come up. Also, if you are on Instagram, I would love for you to follow me on Instagram. We have 2 accounts right here. You can also send me a DM over there, and I'll be sure to respond to you and continue the conversation over there. We want to be on all the platforms. And again, if you have questions, post them in the video below. Any suggestions, we always love to answer your questions and get suggestions. This video is based on your suggestion, and I'm making it for you right now. So, in this scenario, we have a 22-year-old US citizen kid who is trying to adjust his dad, who came to the United States with a visa about 12 years ago and overstayed his stay in the US, and since then also got a DUI a couple of years ago. So, and the question is, can we still adjust the status of this parent? And the other question was, can he do it from inside the US, or should he do this process from overseas? So, first of all, as long as his parent came here legally, in this case he came legal and he overstayed his visa, he only overstayed his visa, even if years pass, like here 12 years, as long as his son is now a US citizen and he was waiting for his son to become a US citizen, his son can now file for a process that is called adjustment of status. He'll be filing forms called I-130 and 485 to adjust his status. And in the adjustment of status, we're also going to have to disclose the fact that his father overstayed by more than 12 years, and also the fact that he has a DUI. Now, remember that a DUI by itself is not going to be a bar for the adjustment of status, but it's really important to understand what happened. The immigration is going to want to know, they want to see the final conviction, they want to see if the fines were all paid, if there's a probation, if the probation is over, and things like that. And again, one DUI should not really be a problem in this case, as long as we can show that everything happened, everything was taken care of with respect to this particular conviction. When there are multiple DUIs, we will have to analyze in more depth the actual conviction. We have to see the recency of this offense and the previous offense. There are many factors that are coming into play when you have more than one incident, more than one DUI, or more than one shoplifting or anything like that. So we strongly recommend, if there's more than one DUI, definitely seek the assistance of an immigration attorney. And even if you have one DUI, it's always good to speak to an immigration attorney, because we can always look at the actual case. It's sometimes different from state to state with how they look at DUIs. So definitely talk to an immigration attorney if there's a DUI. So coming back to this case, the issue here is that the father overstayed here by more than 12 years, and now the son wants to file for his adjustment of status. And yes, it is possible, because the first entry was legal. Remember that as long as there's a legal entry, a first legal entry, there is always a way to adjust your status, as long as you have a child who is a US citizen or a spouse that is a US citizen. In that case, after the adjustment of status interview, that illegal entry essentially will be waived, and that person can still get their green card. So what is really important in this case is to document that there were no other violations except from this illegal entry. So sometimes people come here illegally and then they leave and re-enter. So if there is a re-entry, then we can't really help that person that adjusted their status, that is trying to adjust their status, because the government will see that they came here illegally more than once. Also, it's important to make sure that there's no fraud or misrepresentation. So, for example, in this case, because there was a DUI, we will disclose that on the forms. And you know, people sometimes say, well, do I really have to say that? I say, yes, you do. Because if they find out about the DUI, the actual DUI itself is not going to be an issue. But the fact that you did not disclose it on the form could be construed as misrepresentation, and then you may not be able to finish your adjustment of status. So again, to summarize this, yes, you can adjust your status even if the parent overstayed, as long as the child is over 21 years old. And in this case, even if there is one DUI, as long as we disclose it, we provide all the records, you should be able to still adjust your status and get your green card when time comes. So hopefully that answers this question. This is a follow-up video to a video that we did before explaining how a child can adjust their parents who are here as visitors, and also that video explains how you can immigrate your parents who are currently waiting for you overseas. So if you like this video, make sure to give it a like, share it with somebody who may need this information, and leave us a comment explaining us if you have more questions or any questions about this particular video. Thanks for watching, and we'll see you in our next video.